Cameron and Soren Law here, and today we're going to be talking about Seila Law versus the Consumer Financial Protection Bureau. All right, to get started, we have to go back to the 2008 financial crisis. In response, Congress ultimately passed what's known as the Dodd-Frank Act. As part of the Dodd-Frank Act was the creation of the so-called Consumer Financial Protection Bureau. What they ultimately did is it had its own statute and its own set of purposes, but Congress also transferred 18 separate statutes, various different regulatory aspects, over to this Consumer Financial Protection Bureau and tasked them and gave them enormous amounts of power. So the ability to investigate, issue subpoenas, levy penalties up to $1 million per violation, so on and so forth. What was sort of unique about this new bureau was that Congress opted, instead of the traditional multi-member panels for an independent agency, like, for example, the SEC or the FTC, they opted to vest all of this power in a singular individual. And they made it so that that individual was not removable at will by the president. This individual, this director of the Bureau, could only be removed for inefficiency, neglect of duty, or malfeasance in office. So, how do we get this case? Well, the dispute begins with this Seila Law. It's a California-based law firm that provides debt relief services for consumers. The Bureau was investigating them for possible telemarketing sales violations. So they issued a request for documents. Seila Law challenged the Bureau's authority to issue requests for documents from the firm, asserting that the Bureau was unconstitutional because the director was not removable at will by the president, which is about the best response I can possibly think of to a document request, is to say you and your whole dang agency are unconstitutional. It's not a little bit over the top at all. So they start litigating it out, and then Court of Appeals for the Ninth Circuit ultimately rules it does not violate the Constitution. Importantly, it cited this 1935 case called Humphreys Executor versus United States, which dealt with the FTC. Essentially, you had these five experts who served on this board, and each of these five members could only be removed for cause. And the Supreme Court at the time found that did not violate the Constitution. Seila Law appeals that decision to the Supreme Court. The Supreme Court grants certiorari, and then the Bureau actually flips their position and actually agrees with Seila Law that the removal restrictions do in fact violate the Constitution. Well, that presents a bit of a problem because now we don't actually have sort of a controversy, two people arguing on opposite sides. So the Supreme Court taps Paul Clement to defend the Ninth Circuit's ruling. Now, let me give you a little background on Paul Clement. He was a Solicitor General for the Bush administration in his second term, and he was probably one of the most active Solicitor Generals we've had in recent history. To give you the short version, from 2000 to 2010, no one argued more cases in front of the United States Supreme Court. So, the guy they were tapping to defend the Ninth Circuit's decision, he's a professional, man. He's really good at his job. And as the opinion notes, Roberts wanted to express that Paul Clement ably carried out his duties. Now, as for the decision itself, it's a 5-4 decision. So you got Roberts authoring the majority opinion, and he's joined mostly, we'll get to where I mean not entirely, by Justice Thomas, Gorsuch, Kavanaugh, and Alito. And he ultimately rules that the removal restrictions violate the Constitution's separation of powers. Okay, so let's go through his reasoning. Now, Roberts starts off by citing that the Supreme Court has basically only recognized two limited exceptions to the president's otherwise unlimited removal power for agencies that are acting in with executive powers, enforcement powers. One is the multi-member expert agency, such as Humphrey's executor and the FTC, and in part because it didn't actually exercise any executive or enforcement powers. Second, in a couple subsequent cases, the Supreme Court upheld exceptions for so-called inferior officers, basically individuals who have limited duties, limited scope of authority, and no real policy making, such as independent counsel or officer special counsel. You could also call that as well. So then Roberts turns to the Bureau itself and notes, well, that doesn't really fit with either of those two exceptions. So unlike the FTC and Humphrey's executor, the director can issue binding rules and final decisions. And she can also seek out massive, daunting penalties, upwards of billions of dollars. So, and this director is not an inferior officer either. Again, see, the ability to just issue rules, have binding decisions, and levy these massive penalties. They can actually create policy that way. So Roberts goes, all right. So in order to uphold this removal restriction, we're going to have to extend prior precedent to a new situation, as he sees it. And he simply goes, we're declining to do so. And part of what is concerning to Roberts is that the director serves these 5-year terms and is really not subject to anybody during that 5-year term. The director can't even meaningfully be controlled by appropriations because their funding comes directly from the Federal Reserve. It's sort of built into the statute that created it. The other part that Roberts is really, really getting concerned about is the fact that this lone director is wielding all three different forms of powers. The ability to issue new rules, that's legislative, the ability to render final decisions, adjudicative, as well as enforcement, prosecution going after people, presumably banks and other lending institutions. All of this very, very much concerns him. And so unlike where you've got the multi-member expert agency where you've got different individuals that can sort of balance against each other, you're only going to have a limited number of partisan individuals in there. It's going to be sort of as balanced as possible. They're rotated and staggered out. So the SEC might have a lot of power, for example, but it's not all vested within a singular person that can kind of do what they want for the entire term. So seeing all of this, Roberts concludes, okay, this removal restriction is unconstitutional. Then he's got to move to the question of, all right, if the removal restrictions are unconstitutional, can it be separated from the rest of the Dodd-Frank Act? And the short answer is yes. There's not really anything in the text or the history of the Dodd-Frank Act that demonstrates Congress would have preferred no Consumer Financial Protection Bureau to one that is ultimately supervised by the president. All right, then we've got a concurrence in part, dissent in part by Thomas, and which is joined by Neil Gorsuch. He agrees with Roberts that Humphrey's executor should really only stand for the idea that multi-member agencies that don't wield enforcement power, that's all it really stands for, is constitutional. But then he goes on and says that the foundation for Humphrey's executor, he asserts, is not just shaky, but it's in fact non-existent, and we should probably revisit that decision down the line. Then you get the dissent by Justice Kagan, who's joined by Ginsburg, Breyer, and Sotomayor. Of course, Kagan agrees that the Bureau should be continued to operate, but ultimately disagrees with Roberts in terms of whether this removal restriction violates the Constitution. Essentially says Congress has got wide latitude in order to create these things, and if Congress and the president agreed that this was a balanced way of doing things, then what were we to step in their way? And Kagan is quick to point out that there's a lot of other agencies where you have a singular individual who's in charge and they wield an enormous amount of power, such as, for example, the Social Security Administration or the Federal Housing Finance Agency. Those ones are wielded by a single individual, and there's nothing particularly unusual about removal restrictions. It's pretty standard fare of the FTC, the SEC. These are classic examples. And so really what's going on here is this sort of debate between Kagan and Roberts. Kagan is saying, well, if Congress and the president, when the law was originally passed, agreed, we're going to vest this single individual with all this power and place this removal restriction on there. That doesn't seem to be categorically different than what we've upheld in the past with these other federal agencies. Yeah, they might be vested with a lot of power, but sometimes you have to do that. And Roberts' sort of response to that is, well, we've never really upheld someone wielding, a lone individual wielding this much power and who is not subject to someone who is voted into office, not subject to Congress, not subject to the president. We've never vested that or allowed that with one person before. And so that's really the debate that's going back and forth there. Now, as Kagan notes at the end of her dissent, this decision ultimately sends Congress back to the drawing board. So that raises the question, well, if they want to have this truly independent agency with all its various different powers, how might they do it? Well, there's a couple ideas there, and they're both quite obvious. One is to do the multi-member agency, not dissimilar from the SEC or the FTC. That may ultimately assuage the concerns that Roberts articulated in his opinion. But another alternative would be to separate out the powers vested within the Consumer Financial Protection Bureau into perhaps 2, 3, or 4 different federal agencies, so it's not all being wielded by one person. For example, you could split it up into 3. You say this one is in charge of rulemaking, this one is in charge of any adjudications, and this one is in charge of enforcement. That may potentially also assuage the concerns articulated by Roberts in his opinion. But we'll see ultimately what Congress decides if they want to have this independent agency like they intended back when Dodd-Frank was passed. As always, hope you found this entertaining and informative.